Hello, everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this FedSoc forum on textualism and patent statutory law, in which we'll be discussing patent eligibility, ODP, and upcoming patent reform in Congress. Speaking on the panel today, we have Matthew Dowd, Sherry Knowles, Jean Quinn, and Professor Joshua Sarnoff. Joining us as our moderator today is John M. Rajitz, the managing attorney at Rajitz & Associates. If you'd like to learn more about today's moderator or speaker, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we may turn to the audience for questions. If you have a question, you can enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our speakers and not the Federalist Society. With that, John, thank you so much for joining us today, and I'll hand things over to you.
Hey, thanks, Edith. As she said, I'm John Rogitz from Rogitz & Associates, and I will be introducing our panelists as briefly as I can. First, we have Matthew Dowd. He's the founder and managing partner of Dowd Scheffel, and he's a frequent IP commentator. Next, we have Sherry Knowles, who is the principal of Knowles IP Strategies. She's an IP attorney with over 30 years of experience, and I wish I had more to go into her bio, but she's eminently qualified. And so is Jean Quinn. Jean Quinn is the president and CEO of IPWatchdog, and he is a patent attorney and leading commentator on patent law and innovation policy. Last but certainly not least, we have Professor Josh Sarnoff. Professor Sarnoff is a professor of law at DePaul University College of Law. He's a faculty member and former director of the Center of IP Law and Information Technology. So as I said, we have a very distinguished panel today. We're going to begin with Professor Sarnoff. He's done a lot of research and writing into the history of abstract ideas and judicial exceptions, and that's what we're going to do. We're going to start with 101 and judicial exceptions, and then about halfway through, we're going to move on to obviousness type double patenting. So with that, I will turn the floor over to Professor Sarnoff.
First, many thanks to the Society, to John, and to my co-panelists. And I'm going to start with just correcting our terminology. They're actually not judicial exceptions. They're judicial interpretations of legislative limits to the Patent Act. And I'm going to take you all back 250 or so years to Lord Camden to understand why we have these limits to what can be patented. As Lord Camden said in the Parliamentary History of England in debates in 1774, scientists were entrusted by Providence with the delegated power of imparting to their fellow creatures that instruction which heaven meant for universal benefit. They must not be niggards to the world or hoard up for themselves the common stock. Similarly, Christine McLeod, one of the foremost historians of the Industrial Revolution and inventing the Industrial Revolution, said, if the inventor was no more than God's instrument in bringing his gifts to the community, then he could at most claim users' rights over them. And as all of the judges in the famous Bolton v. Bull steam engine case from 1795 acknowledged, mere principles were not capable of being patented. Thus, Joseph Bramah argued against Watt's patent by stating that the works of men begin at the point where the independent works of God end, and who by his own secret principles and methods establish the elements and their properties, and stock the universal storehouse of endless changes producible by different combinations and proportions. So the question is, if it's both morally and religiously improper to permit patents on discoveries of natural principles and natural things and abstract ideas, why would it then become proper to patent non-inventive applications, dare I say obvious applications, of those same discoveries, as well as the inventive applications which might be attributed to human rather than divine creativity? At least our current patent doctrine prohibits patents on the non-inventive applications. So now let me run through the origins of the legislative history and interpretations of the legislation, and I'll come back to textualism at the very end. But again, we have to look to England for some of the background. A very famous case called Nielsen v. Harford from 1846 acknowledged that the principle of itself could not be patented, just like in Bull. And he says, we think the case must be considered as if the principle being well known. In other words, we treat the scientific discoveries as if they were prior art, even though they may have been newly discovered. Come the 1789 Constitution across the pond to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The relevant language is there to grant exclusive rights to inventors for their discoveries, not for discoveries of geographers, not for discoveries of painters, not for all sorts of other discoveries, but discoveries of inventors, which therefore has a narrower meaning than all possible kinds of discoveries. It really means inventions. The 1790 Act used the language of invents or discovers, who hath or have invented or discovered any useful art, manufacture, engine, machine, or device, or any improvement therein. Art being a term of art, actually not meaning artistic in the common sense that we now hold it, but artisanal. In other words, something that was a process of making something. 1793 Act used only the language of invents, so that now it goes to have invented any new and useful art, machine, manufacture, and also codified in Section 2 that simply changing the form or proportions of any machine or composition of matter in any degree shall not be deemed a discovery. Why is it not a discovery? Because again, at the time they were equating invention and discovery, and invents or discovered was a term understood to mean the kind of inventions or the kinds of discoveries that create inventions. 1836 Act restored the invents or discovery language, having discovered or invented any new useful art, machine, manufacture, or composition of matter. That gets us to the very famous O'Reilly versus Morse case in 1853. But after much consideration, it was finally decided that this principle must be regarded as well known, hearkening back to the Nielsen v. Harford case, and that the plaintiff had invented a mechanical mode of applying it to furnaces. Undoubtedly, the principle that hot air will promote the ignition of fuel better than cold, a discovery, was embodied in the machine, but the patent was not supported because this principle was embodied in it. If the Court of Exchequer had said that Nielsen's patent was for the scientific discovery that hot air would promote ignition better than cold, and that he had invented an exclusive right to use it for that purpose, there might perhaps have been some reason to rely on it. But the court emphatically denied this right to such a patent based on that scientific discovery alone. The 1870 Act inverted the 1836 language. Now it's who has invented or discovered any new and useful art, machine, manufacture, or composition of matter. Case called Ansonia Brass and Copper versus Electric Supply Company from 1892, interpreting that act, says nothing is better settled in this court than that the application of an old process to a new and analogous purpose does not involve invention, even if the new result had not been contemplated. So we now have a non-analogous use to the discovered principles and their applications. That's part of an understanding of what makes for an invention. William Robinson in 1890, in his magisterial treatise on patent law, brought us back to the idea of the religious origins. To benefit by the discoveries of his fellow men is not only the natural right, it's also the natural duty which every man owes to himself and to society, and the mutual universal progress thence resulting is the fulfillment of the earthly destiny of the human race. That underlies the later discussion in the Funk Brothers case that both religious, deontological, God-given stuff being open for everyone, an obligation freely to disseminate for everyone, is also a utilitarian production strategy that works well. That brings us to 1923, when scientists started to get greedy, and they, League of Nations, had a proposal to grant patent rights in scientific property. That right shares much in common with the current legislation in para. It was debated among U.S. policy experts for well over a decade, but it was rejected again because providing property rights and discoveries was inimical to the public interest. Case called American Fruit Growers versus Brogdon in 1931 interpreted the meaning of the word manufacture. And the claim thing had to possess a new or distinctive form, quality, or property. There must be a change in the name, appearance, or general character of the thing from which it was created and had been discovered in nature. Again, non-analogous use, but using a different terminology of marked difference from natural discoveries. 1943, a case called In re Thuau, the Court of Claims and Patent Appeals departed from the Ansonia Brass precedent and held that all new uses of known things, even non-analogous uses, were not patentable. The Funk Brothers case in 48, as in Morse, the discovery of the qualities of the bacteria had to be treated as if already known, and the combination was therefore neither a new thing with markedly different characteristics nor a non-analogous use of a pre-existing and fictionally known qualities of the bacteria. So therefore, that was not eligible. That brings us finally to the 52 Act, where we are currently today. Whoever, again, invents or discovers any new or useful, now we have a new word, process instead of art, machine manufacture or composition of matter. Section 100B, defined process, meaning the process, art, or method, and includes a new use of a known process. Let me repeat, a new use of a known process. The question, therefore, is whether that should be read textually to include all new uses, and similarly, whoever invents or discover any new and useful process should be read textually to cover any new or useful process, and whether invents or discovers still has any meaning that is different from the history, which said you actually had to have a markedly different or non-analogous use or thing from that which you discovered in nature. 1952 Act, as Jeff Lefson documents extensively, had a number of bills that would have explicitly overturned Funk Brothers that were rejected by Congress. Normally, the premise of rejecting a bill and then not especially changing the language in a way that makes it clear suggests that Congress has codified the prior art. Similarly, the premise that Congress sold the 52 Act was that except where explicitly stated, this was simply a codification of existing judicial precedents. Similarly, Section 100B's new use provision was interpreted in a case called Application of Ducci by the Court of Customs and Patent Appeals in 55 to say that it was intended to restore the Ansonia Brass decision rather than to overturn Thuau rather than to generate any new use being eligible. So that just brings us, there are a couple of other minor amendments in 1999 and 2001 where there are specific limitations provided on eligibility that I'll jump over. But it really brings us to the two basic interpretive questions. The first one is, I'll quote from U.S. versus Rutherford, to be sure, it may not always be realistic to infer approval of a judicial or administrative interpretation from congressional silence alone. But once an agency's statutory construction has been fully brought to the attention of the public and the Congress, and the latter has not sought to alter that interpretation, although it has amended the statute in other respects, then presumably the legislative intent has been correctly discerned. So having specifically brought bills to overturn the Funk Brothers case, which adopted the longer history, one would argue that Congress expressly intended for that to be the continuing rule and not to codify a new, much more expansive interpretation. And finally, I will quote from Nick Perillo's article called Leviathan and the Interpretive Revolution. It seems that once legislative history became normal, at the Supreme Court in the 1940s. Its level of use did not shift dramatically in the 1950s or 60s, but it did intensify greatly in the 70s and early 80s. That became a reaction. Usage dropped steeply from the 80s to the 90s and remained low because we're now in an era where people focus on textualism. So my question to all my co-panelists is, if this interpretation and interpretive use of legislative history was what was predominant as the mode of interpretation of legislative language in the 1950s, why would not the current effort to use textualism constitute retroactive judicial legislation that imposes improper judicial preferences back on the legislative language Congress enacted? And similarly, given that what Congress had intended was simply to codify except where expressly changed, that it would essentially create fraud on the Congress because it was sold as merely codifying judicial precedents to now enforce a textualist rather than a continuing to interpretation of the long history. Hopefully that was a short 250 years, John.
Thank you, Professor Sarnoff, and I appreciate that history. It's very interesting. I think first we'll go to Jean, and I guess I'll just ask if there's anything you'd like to add or to respond to from what Professor Sarnoff said.
Yeah, I would. And so first off, thank you for having me here. I really appreciate the invitation. I am a fan of the Federalist Society and all that you guys do, and appreciate you putting together this conversation where we're going to share some different views, which is not something that always winds up happening. And just so everybody knows, Josh and I, we're friends. We've drank beer together, have dinner together, we talk together, and we argue together. And we're about to argue here now, I think. But so let me begin by saying I'm all in favor of textualism, but that requires that we actually follow the text. Okay, so and I love history and I appreciate the history lesson, but I don't think we need to go back to ancient Mesopotamia because anything that happened prior to 1952 is entirely irrelevant because the 1952 Act codified prior law, accepting much and deviating in very significant ways. And we also know that thanks to the legislative history from the 1952 Act, that anything invented or discovered by man under the sun is supposed to be patent eligible. And that's the crux of where we're at now. And I don't think that that's a true statement today based on the interpretation of interpretation of the statute based on the courts. Now, the word interpretation is an interesting one. And I just fell prey to something I was going to try not to do because I disagree with Professor Sarnoff when he says that these are not judicial exceptions, that they're judicial interpretations. What they are is they're really deviations in the plain and obvious meaning of the language of the statute and the Constitution. In fact, they're understood to be judicial exceptions to patent eligibility because that's what the cases themselves have always called them, is judicial exceptions. And now this should be really self-evident because there's nothing in the statute or in the Constitution that envisions or authorizes courts to layer on requirements not found in the statute or Constitution, and which is precisely contrary to the plain and ordinary meaning of the words that are actually used. Now, let's actually look for a minute at the words that are specifically used. Significantly, both the statute and Constitution uses the words discoveries. Now, we all know that Justice Thomas said discoveries are not patent eligible in myriad. He's wrong. It's a one-sentence statute, and he didn't take the time to actually read it because it uses the word discoveries. So discoveries are supposed to be patent eligible. And the term discovery cannot possibly be synonymous with the term invention, as Professor Sarnoff suggests, because the statute says whoever invents or discovers is entitled to a patent if the invention is new and useful. So in the explicit language of the statute, the word invent cannot possibly be a synonym for the word discover. The use of the alternative word or really mandates the understanding that there are inventions and there are discoveries and that they are alternatives and that both are patent eligible. I'll stop there because I want to give others some time to react to what has been said as well. But thank you very much.
Okay, thanks, Gene. Sherry, do you have anything to add to this debate?
Oh, of course I do. Yes. Thank you again. Thank you for letting us talk about this. Thank you for doing it in the context of textualism. And we think textualism is very important when we talk about the structure of our government. And I know you are a fan of Justice Scalia, and I am also. And so quotes from Justice Scalia are certainly appropriate here. For example, to safeguard individual liberty, structure is everything. And when talking about structure, that's the structure of our laws. And so when we end up interpreting our laws in ways that are above and beyond the wording of the laws, then our government becomes fluid and uncontrollable. And we have to stick with the rules. If we don't like the rules, we need to change the rules. We know that there's a pending law on the PARA Act trying to change patent eligibility. That will probably go on for a while. I know Josh has some strong ideas on that. And we might mention that Josh has a law review article that came out. I'm giving you an advertisement here. A law review article that came out in September 2024. I'm surprised you didn't refer to it. White paper on proposed revisions by the Patent Eligibility Restoration Act. I'm giving you a little shout out there. However, I'm going to give myself and Tony Prosser a shout out also, because we have the exact opposite law review article that's on unconstitutional application of 35 U.S.C. 101 by the U.S. Supreme Court. So I hope that the people who are listening today read both of these law review articles, because when you put them together, then I think you get a full version of what all the issues are. I'd like to just mention a couple of things. As Jean said, we're not going to go back to ancient history. We want to talk about the 1952 Patent Act and what happened and then where we went from there. What we did in this law review article, which I think was very important, was we analyzed the Patent Eligibility Statute 101, starting in the 1790 and going all the way to 2011. And then we compared that to Supreme Court case law in the, going on patent eligibility. And we showed how the Supreme Court case law was completely diverged from the wording of the act. And if we just start for a moment at the 1952 Patent Act, we've heard that, of course, and we know in 101, it defines a invention there. And importantly, which we haven't talked about yet, in the 1952 Patent Act, it not only had a definition of 101, what's patent eligible subject matter, but it actually defined the word invention. And it added that, and it said an invention is an invention or a discovery. So it did two things. It affirmatively added a definition of invention to be invention or discovery. And that's the very first definition of the code. It's 100A, 35 U.S.C. 100A. Okay. And interesting, we went back and read some of the legislative history while they were debating the 1952 Patent Act. And interesting, the DOJ had someone speak at the hearing on that. And I want to just read what they said. This is what the representative DOJ said in going up to the 1952 Act. Section 100 of the bill, definitions, defines invention to include discoveries, which is the new definition they put in. While the term discovery is used in the patent law as synonymous with invention, has been recognized that the act, central part of the invention, under existing laws, it's not patentable. And the section might have the effect of creating doubt as to existing law on the subject of discovery, and might result in opening the door to a huge new area of patents and permit the creation of monopolies and blah, blah, blah. So the DOJ criticized this new definition of invention that went into 100A. The response to that in Congress was they said, "Thank you, Mr. Brown." And they went forward and they never changed it. So obviously they heard the criticism, they did not accept it, they put in the definition and went forward. And then there was another speaker in the 52 Act talking about patent eligibility. And this is somebody who was worried about Funk Brothers. And this was somebody who had a chemical company. And I think he went into history. We don't talk about this person enough, and Mr. Fellner. And he raised the issue of the highly controversial 1948 Supreme Court decision in Funk Brothers, holding that discovery of a new mixture of a bacteria that had a commercial application is not patent eligible. And so the congressman said, as I understand it, from the point of view of industry, their requirements would have been met by the adoption of Section 101, as it was written before. And Willis said, you see in HR 9133, did you not see that we added a definition in Section 100 of the new bill? Now with these definitions, wouldn't that supply the purpose of the second paragraph of the old bill that you want? So basically they're saying, look, we put in an explicit definition that invention means invention or discovery. Doesn't that get over the Funk Brothers case? Doesn't that basically overrule it, and specifically overrule it by Congress? And they went back to it twice. And then they've kept that definition of invention as invention or discovery all the way through, and it exists today. You can Google it right now. 100A is an invention or discovery. It's still there. And then with regard to the judicial exceptions, as Jean said, this is not a judicial interpretation. These are exceptions, and they're referred to by the Supreme Court as an exception. And you can go case after case, and it will refer to that. For example, even in Bilski versus Kapos, Kennedy said, this court precedents provide 3 specific exceptions to 101's broad patent eligibility principles, right? Law of nature, physical phenomena, and abstract ideas. The court itself confirms that these are exceptions, not interpretations, and that they are carving subject matter out of a statute. That's unconstitutional. I'll leave it at that.
Okay, thank you, Sherry. Professor Sarnoff, I want to give you a chance to respond, but first I want to draw Matt into the conversation too here, and give him his due time. Now, Matt, another one of my favorite Scalia quotes is that Congress does not hide elephants in mouse holes. And
I was about to use that again. Okay.
And that's what it feels like to me, especially how, just crazy and out of control 101 jurisprudence has gotten. And it's become basically like the Supreme Court standard for obscenity, where it's just, I know it when I see it, but there's no guiding principle. And like Justice Thomas said, the exceptions have swallowed the rule. And so, or swallowed all of patent law. And so I just wonder, how do you feel about this? Is it an exception? Is it in, a construction of the existing statute? Where do you fall on this issue?
Oh, thanks, John. Thanks for having me. So yeah, let me follow your question with a few points, address your question, a few other points that were raised. In terms of the judicial exception versus judicial interpretation, I guess one way to look at it is maybe it's 2 sides of the same coin. Right, there's no doubt that the Supreme Court and the Federal Circuit repeatedly refer to them as exceptions to the statute. Right, that's not debatable. I guess the real question is, how does that impact whether you see the decisions as being consistent with the statute or inconsistent with the statute? So that's my view on that. To your point in terms of swallowing the rule, I think that there is a strong argument to that. And let me bring up quickly just one example, 2 cases recently from the Federal Circuit that I think epitomize perhaps your point. Right. So there was an earlier case, I believe it was 2004 or 2003, U versus Apple. It was directed to a patent claiming a digital camera. It was that was the main substance of the invention. It had some computer-based features in terms of how to better process the imaging that was taken by the camera. But at the end of the day, it was a claim to a camera. And if you were to apply a strictly textualist approach of the statute, I think that there would be no debate that a camera qualifies as a composition, and that's one of the categories of patentable subject matter. Unfortunately, in that case, the Federal Circuit, following recent Supreme Court precedent, concluded that that claim was not patent eligible, meaning that it fell within one of these judicial exceptions. It's hard to reconcile that decision with a textualist approach. Then more recently, the Federal Circuit had a different patent at issue, and this was in the case of Contour IP Holding versus GoPro. Another claim directed to essentially a digital camera, the slightly different panel, one overlapping judge, and this instance, the court concluded that it was directed to patent eligible subject matter. Therefore, it was a composition. And I think that those two cases epitomize the confusion that exists in the current state of the law. And I know we're going to get into para shortly, and maybe I'll limit my remarks to those examples. Hopefully that gives you an example of these exceptions swallowing the rule.
Okay, thanks, Matt. Professor Sarnoff, I want to give you a chance to respond briefly, but we are a little short on time already, and we want to get to
try to
para.
be as quick as possible, John. First, on textualism, the question is public meaning as to whom. So if you look at the constitutional language, it says inventors for their discoveries. It doesn't say scientists for their discoveries. So there's an argument that if the statute means what Sherry and Gene think it means, then arguably it's unconstitutional because Congress doesn't have the power to grant that, unless it does under the Commerce Clause, which again, under an original understanding of the Commerce Clause, was much more limited. The second is Fluke looked at the word process and specifically said process doesn't mean all processes in the common general meaning. It has a technical patent law meaning, and therefore you don't adopt the plain and ordinary meaning. And most importantly, when you get to the actual language of Section 100A process, P.J. Federico, the other main drafter of the Patent Act, somebody who ought to have known something about it, based on his recommendations, the Patent Office argued in the Ducci case that I mentioned from 53, that it was a non-textualist meaning. It was intended to restore Ansonia Brass, not to be all new uses. Jeff Lefson, again, let me refer you to his Inventive Application in History article, has a terrific discussion of the 52 Act, including Fellner and all of the things, and he concludes that having had these provisions to, overturn Funk Brothers expressly and not having adopted it, it's not at all clear that the language of the 52 Act actually adopted a much broader position rather than codifying the judicial precedent. So we're going to argue about this for a long time. I'll just leave with one thought about para, because again, this is not going to get fixed judicially. It's probably not going to get fixed legislatively, and I doubt it will ever get fixed constitutionally. Para basically codifies some of the same exceptions as a legislative matter, but limits them to as such. And I go back to the question, if the discovery as such isn't patentable, if scientists aren't entitled to patent their discoveries, when doing so will allow them to dominate both inventive applications of those discoveries and uninventive applications, why do we want to grant rights only in the uninventive applications of the discoveries themselves? If we're going to do that, let's just grant rights in scientific property like the 1923 League of Nations. And of course, we shouldn't do that. And if we shouldn't do that, we also should only grant patents on inventive applications of the discoveries, not on the discoveries themselves or uninventive applications of them. That's similar in a sense to what we're going to talk about in double patenting, where you can't get obvious variants, but not the same. So we should probably turn to that, but I'm sure that the others would like to say something about para before we do.
John, can I just have 20 seconds?
If I could add one quick point on that,
Go ahead, Matt.
because I think one thing that's missing from this entire conversation, particularly from a textualist perspective, is understanding how inventions are deemed patentable, right? So Section 101 is one thing, but Professor Sarnoff claims that, well, if we pass para, that will allow the patenting of, quote, uninventive applications. But with respect, that's not correct, because you still have to consider Section 102 and Section 103 of Title 35. Section 102 deals with novelty, and novelty actually deals or should deal with any concerns about patenting something that's discovered that's already known, because if it's already known or already existing, it can't be patented under 102. Section 103 does the work of weeding out, quote unquote, non-inventive applications, or the other phrase was used was uninventive application. If you consider the statute in combination 100, 102, 103, and then 101, you understand that much of the argument being presented that we need a rigid or aggressive enforcement of 101 is misplaced, because the work of weeding out uninventive applications is actually done by sections 102 and 103.
Actually not, Matthew, because the discovery itself, if it's novel, is what's creating the creativity for the inventive application. So if you want to make scientific discoveries prior art under 102, then we won't have a dispute, but you're certainly not going to go there, I'm sure.
Well, no, but they
Yeah,
are.
thanks, Gene. Go ahead.
I
No,
mean,
they're not. Only
so
if they're previously
no.
known, Gene. Only if they're previously known. If
I just want to say that patent eligibility has become untenable, and regardless of your opinion on what is or should be patent eligible, it really is undeniable that it's just an unworkable situation that we have. And in large extent, not exclusively, but in large extent, we find ourselves in this nonsensical position because both the Supreme Court and the Federal Circuit have willfully, intentionally, and explicitly refused to define what is an abstract idea. And that's how you get a camera being patent ineligible in you versus Apple. And it's also how you get the PTAB ruling that an MRI machine is abstract. Now, neither a camera nor an MRI machine are abstract, but that's the law. That's where we find ourselves. I mean, what we should do is define what it means to be abstract and realize that if I can pick up the invention and throw it at your head and it leaves a mark, it is not abstract. And if you want to go,
creativity of that is what is abstract. And if that's really based on a,
but that's a novelty question. The
right,
novelty
so
is the novelty something.
Make new discoveries prior art against everybody, then you don't have a problem like this. Conversely, if you just want to make everything patentable, give a patent on the new discovery directly. But that was what was projected.
Under that view, nothing is patentable, period, ever.
No, it's not true.
Of course it won't be, because every invention starts with a discovery. Every single invention starts with a discovery. And that's how we also get into the situation that an axle violates a natural law. I mean, I suppose a chair violates a natural law too, right? Because gravity, you should just fall down to the ground, or you should. I mean, it just becomes lunacy. And well, the last thing I will just quickly say is I defy anybody to look at claims and accurately predict whether or not they're going to be eligible or not. And that's why we have this enormous problem. Now, what I can do is I can put two sets of claims in front of you and say, one of these is good, one of these is bad, and every one of you will pick the bad one, and every one of you will identify the good one. But it's not an after the fact analysis that matters. It's a before the fact, because we're not talking about things that are not inventions. What we're talking about is the claim was made at a time when the law was different, interpreted differently. If you knew what was going to be applied, you could claim these things. So we're throwing out a baby with the bathwater and getting rid of numerous inventions that can and should be patented simply because we don't have an understanding of basic words. What is abstract?
I think we should also just point out for a minute how much damage has already occurred because of the interpretation of 101 and the judicial exceptions. You know, I'm primarily in the life sciences and the pharmaceutical and biotech field. There are complete areas of research that have been shut down and will probably never come back because of the interpretation of natural products. Most of the antibiotics we take are natural products, and they've saved so many people's lives. And many of those natural products, which are fermentation products of bacteria, are anti-cancer drugs. And there are people on a daily basis all over the world taking IVs on medicines which would never have been invented under the application of natural products as we exist now. And we see in the life sciences area complete shutdown of all the natural product research, which could be fantastically important. There are new anti-cancer drugs that we're not going to have, and there are new antibiotics that we're not going to have because of this interpretation. And that costs lives. People are dying because of that.
All right, thank you, Sherry.
and Jake Shirkow and Greeley just posted a article on Myriad at 10, with or without statutory change. The effect of Myriad on the biotech industry has been difficult to gauge. If you look at the thankful to Sherry document, white paper that I published with Charles Dwan, you will see that the most recent scholarship says that actually determining what is patent eligible is less uncertain than applying most of the other patent law
That's
doctrines.
simply not true.
I mean, that's not true. I
factually
live in
false.
this area. I can tell you, I live in it and I talk to the people. I know it's shutting down research. It has shut down programs. It has shut down life-saving medicines. There's no question about it.
Well, we know that the Mayo, we know that the Cleveland Clinic and St. Jude's both have deviated from what they were otherwise doing because of this. We know that to be fact. They have stated that publicly.
John,
And
we probably move
Yeah,
on to
yeah.
Everyone, I think we need to move on. I guess we
Right.
should do
Well,
a
you can
follow-up
see that this
webinar.
is not going to be resolved soon.
It's not. So what we're going to do now, I'm going to read a little bit about para to let everyone know what judicial exceptions are being codified. And then we're going to do a lightning round with our panelists as to whether it's good or bad. And then we're going to move on to ODP because we do want to address that a little bit. So according to para, mathematical formula that is not part of an invention is not patent eligible. Also patent ineligible are mental processes performed solely in the human mind, unmodified human genes as they exist in the body, unmodified natural material as the natural material exists in nature, and perhaps most importantly, if you do AI and high tech, also ineligible is a process that is substantially economic, financial, business, social, cultural, or artistic. Now, according to para, there are certain exceptions to that last bit. And one is any process that cannot practically be performed without the use of a machine, including a computer, shall be eligible for patent coverage. And so there's exceptions, and then there's exceptions to the exceptions. Let's start with Matt. Do you think this is a good starting point? Is it better than what we have, or what do you think?
Yeah, it's certainly better than what we currently have in the current state of the uncertainty. As Gene pointed out, we don't have a definition of what abstract is. And like any legislation, it's not perfect, but we need something better. And I'm glad you brought up the point about artificial intelligence. So much work being done in that space. Patenting and protecting of those ideas and inventions are going to be critical moving forward for the U.S. economy, U.S. innovation ecosystem. And as it stands now, para looks to be the best hope to at least improve the law now.
Okay, thanks. We're going to go Gene, Sherry, and then we'll give Professor Sarnoff the last word.
Yeah, I agree with Matt. I think para is as good as we could possibly hope for. I know that there's people out there that say that if enacted, that would make artificial intelligence patent ineligible. That's simply not true. Because in the act, as you were mentioning, if a computer is used, then it would become patent eligible. And I defy anybody to give me an example of artificial intelligence being used outside of some type of computerized embodiment. So it would be a move in the right direction. The criticism, the valid criticism that I've heard is that, well, what this will probably do is move all of these issues into 112, which it will. I think it absolutely will. But if it moves them out of 101 and into 112, then that forces during litigation that the judge is going to have to interpret the claims, which is going to require a look at the specification and the prior art and the prosecution history in order to figure out what is really being claimed here, which would be an enormous step in a positive direction above motions to dismiss. And my last thought here very quickly is, let's stop and talk about the motion to dismiss for a second. We're all of it. I won't say how old we all are, but we're of a certain age that when we were in law school, if we actually talked to our professors about a federal complaint being dismissed on issues like this, we would have failed the civil procedure course. I mean, the motions to dismiss are never granted, except in our area where they're granted all the time. Why is that? It's because we're screwed up and the rest of the law is right. A motion to dismiss is supposed to be an enormous threshold, and it has become ordinary in the patent litigation arena.
Okay, thanks, Gene. Sherry?
I agree with Gene and Matt that getting para passed is better than where we are now. And maybe it might open up some of these currently completely shut down areas of life sciences research that we need so badly. So I'm in favor of that if that's the proper remedy. I think that we should also look, we've just had the Loper-Bright versus Raimondo case where the US Supreme Court's had a renewed appreciation for the structure of our government and looking at the laws as they're passed. And so maybe we should go back and, you know, knock on the door and say, remember Loper-Bright, and see if they'll look at this and reconsider their 101 statutes, their 101 case law. Also, we shouldn't forget about Henry Schein versus Archer, where Kavanaugh actually said there is no statutory authority for judicial exception to, in that case, the Federal Arbitration Act. So I think we should do something. I would give a big shout out to former Chief Judge Michel for his hard work on the PARA Act. I think he's done a great job. He's a tireless advocate. So great, you know, thank you to him.
All right, thanks, Sherry. Professor Sarnoff, what do you think about the new legislation?
I'll just, again, be very brief so we can get to obviousness double patenting. I posted in the Q&A link to my white paper, 3 main points. The first is the uncertainties complained about are really a sham for not liking the outcomes. In regard to the outcomes, you know, you can disagree, but diagnostics have exploded without the patent rights. There's a lot of argument as to why we don't need patents on uncreative applications. But the certainty is this will just generate all sorts of new and difficult questions about where to draw the lines. If we want to say that scientific discovery should be patentable either as such or in regard to non-inventive applications in light of those new discoveries, then we should just codify that. And that will be much simpler and clearer to apply. I don't think we should. 250 years of history says we shouldn't, but I'll end there.
Okay, thanks everyone. That was a great debate. And like I said, I wish we could continue it. We are, however, going to move on to obviousness type double patenting. And we're going to begin with Sherry. Sherry's going to give a little bit of a how we got here, history of ODP, and maybe the potential conflict with other statutes in US law.
Okay, great, thanks. You know, we can start at the title, which is Judicially Created Non-Statutory Doctrine of Obviousness Type Double Patenting. I'd say the first 5 words of that really say it all and prove that it's unconstitutional. Because as we know, Article 1, Section 8, Clause 8 of the Constitution gives Congress the sole right to create patent law, and not the judicial branch, and certainly not the Patent Office. So when you call it judicially created, you get a big check. That's unconstitutional as a violation of separation of powers. You get non-statutory. Well, given that Congress is the only branch of the government that can make law, check. Unconstitutional is a violation of the separation of powers. And then you get doctrine, which is a very interesting word. So what does doctrine mean? Well, we know that Congress doesn't pass doctrines. Congress passes statutes. So the fact that it's a doctrine, again, means it's not passed by Congress, which means it's not authorized by the Constitution, which means it's unconstitutional. So, you know, we go back to what you had said before. Congress doesn't hide elephants in mouse holes. Okay, the terminal disclaimer doctrine is a very big elephant hiding, if at all, in mouse holes that don't exist in our statutes. You look at in the 1952 Patent Act, the 35 U.S.C. 253 was passed. That did not mention obviousness type double patenting. It mentioned that you can disclaim all or a terminal portion of the patent. That's all it said. It did not any way legitimize obviousness type double patenting as a doctrine. And we know that because P.J. Federico, who was an advisory on the Judiciary Committee during drafting of the 52 Act, said there was no specific reason for the codification of 253, and it was not tied to double patenting. But they said that there were some people who were talking about it during the discussions on the 52 Act, and said, oh, that might be useful for, double patenting. But there's nothing in the congressional record that says that that's the purpose for it. And certainly the language is not there saying that that's why it's there. And we have also interesting history on double patenting at the Patent Office itself. So even before the 1952 Act, the MPEP included a double patenting section going all the way back to 1949. And it said that it had two statutes focusing on singular tense for a patent, but it only talked about divisional practice only in terms of double patenting. And that's really all it said. And the 1952 Patent Act then codified divisional practice. But even when it codified it, it didn't say anything about terminal disclaimers. Okay. And then in 1961, MPEP third edition, it again included a discussion on terminal disclaimers and said that they cannot be used to overcome double patenting. This is the Patent Office. In 1961, 9 years after the 1952 Patent Act said, sorry, you can't use a terminal disclaimer to overcome double patenting. They continued with that for every single MPEP edition until 1967, which is the 13th revision of the MPEP. So even the Patent Office didn't know which way it's going. If the Patent Office is swinging from one side to another and said you can't use a terminal disclaimer to overcome double patenting after the 1952 Act, then obviously the 1952 Act did not instruct it what to do. Okay, and then it said after that in 1967, the next MPEP said, when a patent is involved, rejection on the ground of double patenting may be overcome by filing a terminal disclaimer, but only if the claims do not overlap. So here they are making up law again, and that's not in the statute either. And they've even changed their own mind on how it can be, how it was supposed to be, they thought, useful. And that shows they had no guidance, and they had no guidance from the statutes. Then in 1964, 12 years after the 1952 Patent Act, we get the case of In re Robeson. And In re Robeson was a case where there were two patents, and but the second one was filed while the first one was still unpublished. That's when you didn't publish until the patent issued. So it wasn't published, so it was actually trade secret. The inventor voluntarily, without being asked, submitted a terminal disclaimer because there was a 2-year difference in what would have been the patent term. And so they just voluntarily submitted without a rejection. The PTO said, no, we don't accept that. And they said they would not accept a terminal disclaimer. It went up to the CCPA, and the CCAP said, oh, I bet the Congress would think this might be a good idea. So we're just going to let them do it. It didn't say it's complying with statute. They said it might be a good idea. Then after that case, that's when we get 37 CFR 1.321C enacted. So obviously you have the judicial starting it, you have it then taken up by the Patent Office after they've flip-flopped all over the place on what the law is, because there was no law. And that really answers the question. And so my view on double patenting is it's completely unconstitutional. And the law that we have is 103 on obviousness. It's been in the law the whole time. If you claim priority back to a single case, the other continuations that you file or divisionals have the same priority date. They're not prior art because they have the same priority date. And therefore, there should be no terminal disclaimer. If you file a second application prior to the publication of the first application, that's not prior art, at least under 102 B2C, under the AIA now. And then if you file another one after the publication of your first one, tough luck, that's full prior art.
Okay, thanks, Sherry. That was great. Matt, I'm going to go to you next. Do you have any additional background or context you want to provide to this discussion? He might have froze on us here. Okay,
Why don't I jump in while he's?
yeah, go ahead, please do.
So
Yeah.
just a couple of very quick things. The first is, every patent lawyer knows A means one or more. So when the statute says for statutory double patenting, you can only grant a patent. It has to be interpreted by the judiciary. They've said it means only one. Now we get to non-statutory double patenting. And again, we're back to the same question. Is the creation of obviousness double patenting an interpretation or just judicial common lawmaking that is unauthorized? Sherry views it as judicial common lawmaking. I view it as interpretation. I don't know that it's a good interpretation. I don't really care that much about double patenting, but again, when Congress reenacts statutes, including in 1999 and 2011, without changing what was understood, it's at least a strong indication of legislative ratification, even of improper prior interpretations. So the most important thing I have to say, and just, because it's fun to poke, is it seems to me that what Sherry really wants to do is to overturn Marbury, where the Chief Justice Marshall said that it is emphatically the duty and province of the judiciary to say what the law means. And if that means that it doesn't cover something, or it does cover something that you don't particularly like and isn't a purely textual reading, that isn't unconstitutional. That's just the job of the judiciary. I'll stop there.
John, can I jump in here
Yeah,
for a sec? Because the truth is that the Congress did address this in the AIA. If you look at 102 B2C and 102C, what Congress did is they moved what had previously been a double patenting 103 issue into 102, where they talk about common ownership, and common ownership can't be used against you. So an extremely strong argument could be made that at that point in time, Congress just did away with double patenting. The other thing here too is talking about this still in a time frame when you get 17 years from or 20 years from the filing date, not 17 years from issue, is ridiculous. I mean, the whole idea of terminal disclaimer was so that you couldn't push off when these things fell into the public domain. And under the filing date governing the term, it's no longer a consideration, except for when the patent office themselves initiates unreasonable delay and you get added term. But why should I or a patent owner suffer the consequences of unreasonable, by definition, unreasonable patent office delay and say, oh, well, you've got to lop off. I know that they delayed giving you this right, but that right has to end at the same term of the patent where they didn't unreasonably delay. And then another thought here too is in the world where we have the Henry Shin case, where they say that the Supreme Court says there can be no judicial exceptions to statutes. That is probably why, if you haven't paid attention to this, you need to clue in. Both the Patent Office and the courts have stopped referring to double patenting as the judicially created non-statutory doctrine. They just refer to it as obviousness type double patenting. Why? Because it can't possibly exist after Henry Schein, if in fact that meant what it actually says. And then the last thought here about a patent. Let's be clear. The big part of the problem that we have here is you're getting multiple patents covering what most people would call the same invention, because of examiners are refusing to give you the full extent of the protection that you're entitled to in the first application. And then you file a continuation, and then they say, oh, okay, well, now I see that you're entitled to broader protection, which I should have given you back in the first application, but I didn't for whatever reason, so I'm going to give it to you now. But, oh, by the way, even though I've delayed, you have to lop off any term because I should have. I mean, it's just nonsensical. You get multiple patents in these areas because examiners refuse to give you what you're entitled to. That's not an applicant problem. So a lot of these points are saying, applicant, you're acting badly, applicant, you're doing this, applicant, you're doing that. No, it's the office. The office is doing this. And that's all I got to say about that.
I want Matt to have the last word. So let me just
hold on.
jump.
Oh, sorry.
Yeah,
I hate, but we've only got a minute left, and
Fine.
it's okay if we go a little bit over, but I want to get Matt involved here, come back to you
Sure.
now that you're back, and just get your thoughts on this. And like I said, if you go a little over, that's fine. I want to give you ample time. So go ahead, Matt.
That's fine. Apologies for dropping off there for a second. It's obviousness type double patenting. It's a very confusing subject area. The way I like to think about it, though, and I'll leave this one thought, and I think Gene was hinting at this, right? Is there's no question it was a judicially created doctrine. In fact, the most recent Federal Circuit decision, Allergan versus MSN Labs, written by Judge Lurie, they refer to it as a judicially created doctrine. But it was it's an artifact of patent law when patents were 17 years from issuance, and you could have patents extending sometimes decades past the first application. Now that we have a 20-year term, it's largely obviousness type double patenting, largely less relevant, except as Gene pointed out, the instances of patent term adjustment. But this is my takeaway. Ultimately, when the patent term was adjusted in terms of 20 years from filing date, and there was the opportunity for patent term adjustment, the concept it really is trying to mimic, regardless of when your patent issues, you still get 17 years of that exclusive right. And that's where the tension exists between having multiple patents as a product of the prosecution process, as Gene points out. But that's really what it comes down to. An inventor, once that patent issues, should have approximately 17 years of an exclusive right. And it shouldn't be lopped off artificially because another patent in that family was terminally disclaimed or issued earlier. So I'll leave it at that.
Okay, thanks, Matt. So we didn't even get to the controversy of the day, which is the Select and Amgen decisions. We might have to leave that for another webinar. If anyone's got to go, I understand. We might go 1 minute over to give Professor Sarnoff the last word, and then we're going to end it. Go ahead, Professor Sarnoff.
I don't want the last word. I just want to make two quick things. First, in addition to the 17 years, there was always a concern with requiring common ownership so people wouldn't have to obtain multiple licenses from multiple people for the same obvious variants of what they had already licensed. The other thing is, I think we'll all agree that some of the recent decisions result in bad outcomes. It seems to me this is an area where it can go back to Congress, and Congress should act to fix problems that are created by patent office not processing properly or by the order in which things are issued, so that you don't lose your life. And as I've suggested, just a contingent terminal disclaimer that assures that none of your patents will go down, but they all end at the same time if they need to, should solve that problem.
And if I can say one final thing before we end, I'd say let's just comply with 35 U.S.C. 103 on obviousness, and that will solve the whole thing. That's the law.
Amen. Okay, well, thank you everyone very much for joining us. I really appreciate it. It's been a great debate.
Yeah,
Yes,
thanks. It was great. Thank you, everyone.
Thank you.
Yeah, on behalf of the Federalist Society, thank you so much to Matthew, Sherry, Gene, and Professor Sarnoff for speaking, and John for moderating. We're so grateful for your time and expertise and spirited debate today. Thank you also to our audience for joining us. We really appreciate your participation. You can stay up to date with announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.